Hi there and welcome to another video. This video is to empower you who is in a leadership position or management position, and I would want to make sure that you are making the right decision or you are following the right process when it comes to terminating employees during the probation period. So I'll start by defining what a probation period is. Then we will look at the law. What does the law say about the probation period? Then I'll also talk about the termination notice. And finally, I'll end by sharing with you what are the emerging issues as far as termination of employment during probation period goes. A probation period is a period provided for by the law whereby both parties can be able to test each other. I want to use a simple definition as possible. So the law does understand that whenever someone is new in a job, whenever you are hiring someone beyond how they perform during the interview stage or beyond even how good their CV is, you sort of somehow need time to be able to see whether are they really a good fit for the organization. And even also for the employee, the law provides for them such that also they could join this organization. The organization might have sold themselves very well to the candidate, but then when they join the organization, they find that things are very different. That is the purpose of the probation period. It's a period for both parties to sort of test the relationship and see whether are they comfortable with taking things to the next level. And by next level, I mean either you confirming the staff member or even the staff member deciding whether should they stay or should they quit. So what does the law say when it comes to the probation period? So the maximum currently provided for by the law is 6 months. So an employee can be on probation for 6 months. And also the law says upon expiry of 6 months, an employer can also extend that probation for another 6 months. So you normally find then the probation period, the maximum probation period is 12 months. But what you find in practice is that an employer will give an employee, let's say 3 months probation period, so that if there are things they discover within those 3 months, they can also extend the probation to another 3 months. And during that period, for sure, the employer will know whether they have the right person on board. For sure, I don't recommend having someone on probation for 6 months and then also extending for another 6 months. Then that means there's something already not working for either party. And if it gets to that point, then separation is the best decision for both parties. But in some instances, you find, especially for senior management position, or where a company, this is the first time maybe they're hiring for that position, or they are not so sure of how things will work out, sometimes you find they don't want to work with the maximum period, the first 6 months. And then depending on how things turn out, then they can extend for another 6 months. So it depends with the company. The more senior you are, you shouldn't expect to be probation on 1 or 2 months. The longer the probation period will be or should be, or depending on what the company is, the goals of the company. For example, if I'm setting up a new company, we know that no one is guaranteed of the future. So if I come and I give you a probation of only 2 months and then things don't go according to plan, we might find there's a lot of conflict or there's a lot of push and pull between the two parties. So to be on the safe side, I can give you a probation of 6 months and then give you another extension if at all there's a reason for that. So having understood what the law says about the probation period, then let's look at the termination. So if the relationship is not working, what does the law say? Because here we are guided by the law. It's not the preference of the employer or even the employee. So as it is right now, the law says it provides for a minimum of 7 days for termination to take place. So if you haven't been confirmed, if you're still under probation, then the company or you as a manager, you can give the employee 7 days. However, you have to be very careful on this. Whereas the law says 7 days, that's the minimum, but the period can be longer depending on your employment contract. For example, you normally find senior positions, they'll give you 30 days, even if you're on probation. Even for the other junior position, if by the time of hiring this person, you indicated in the contract they need 1 month notice, even during probation, to terminate that contract, then you need to realize that that is binding for both parties. So it's not to come and say you as an employer now, you give them 7 days, whereas the contract says 30 days. So if you indicate 30 days, it's for both parties to adhere to those 30 days. And on to my last point, what are the emerging issues? And this is the reason why I even decided to have this video for you. Now, in the past, whenever you are terminating someone who's on probation, you did not have to provide a reason. And I would say that really favored employers, and it was not favoring the employees. So you could call someone in the office and you just give them a letter. Maybe you don't like them. Maybe you don't like the way they smile. You don't like the way they eat lunch. You don't like... I mean, people are being fired for all manner of reasons. So what has happened is in the month of, I believe we are now in August, when I'm shooting this video, last month, the court ruled that just like permanent employees, you must also give a reason to the staff who is on probation. So what the courts try to do is to bring equality, because no employees, someone on probation should not be looked down upon, compared to someone who's on permanent terms. So right now, if you're a manager, if you are a business owner, you need to know that if you don't give your employees, even the ones who are on probation, a reason, a valid reason, and a written one for that matter, they know that you'll be contravening the law, and the employee has a case against you. And the reason why the courts ruled this way is because of a case where Mount Kenya University, they terminated their staff way back, I believe it's the year 2016. And so when the courts were making judgment this year, 2021, in the month of August, then the courts found that it is proper. Yes, you can terminate someone who's on probation. You can still give them 7 days or 30 days if that is what you've indicated in the contract. But you can't just let them go without giving them a valid reason. That's what the courts ruled, and that's what the courts brought forward. So there you have it. Make sure you follow the due process. Make sure everything is documented, and that way you create transparency for the employees and even for yourself.